welcome back to the second part of drafting a basic estate plan and putting it together. Now, before I was going to do everything, I realized I was getting way over my head, and I got 25 minutes into just putting the will together and realized, I probably should break this up into two videos. So the first part was the drafting of the will, and the second part is going to be drafting some of the other documents that we have talked about. Everybody should have a medical power of attorney. When you come into your office, I think every attorney should know how to put together a medical power of attorney, a financial power of attorney, a HIPAA, and a directed to physician for all clients, because these are incapacity documents. These help out so much if your client ever became incapacitated. So, we're just going to start off with this. Is Taylor planning and designating any co-agents to serve jointly? No. Let's just put it in here. We're just going to do, I usually do 3 deep. And so logically, so you can understand why I think 3 deep. I think of most people want their spouse first, all right? Then they usually want an older generation, like a parent. So, but if someone doesn't have a spouse, they're going to think, well, I want somebody older than me, my parents' generation. And usually then people think, sibling age, their own generation. So they pick a sibling, and then younger generation, which is like a child. And that's if someone comes in and is doing this when they're younger. Now, of course, that's different when you're dealing with older people. They usually want to include all their children because they kind of want everybody to feel included and like everybody's in the document. But if someone comes in and they're in their 30s or 40s, they're usually going to think in that kind of process. Older generation, their generation, and then the younger generation. And I will even put a 1-year-old child in the younger generation category, understanding that if the older person can't serve and then the sibling can't serve, the younger kid is now serving, that this is probably 40 years, 50 years down the road, and they just never redid their documents. And don't be surprised if people don't come in and do their documents more often. So usually I think in the process of 3. And so if I was going to do mine, of course, I'd pick my wife first, I'd want her to do it. In medical power of attorneys, generally they ask for the address. I'm not going to put my wife's phone number in here just because I don't want you guys calling her. And then I'm going to think older generation. For me, it's my dad. My dad's still around. I want him to do things. And then I'm going to put my son, because I'm going to go, okay, well, if my wife isn't here, my dad isn't around, odds are my son is over 18 years of age. He's almost 12 now. So I'm going to put him in there. That's only 6 years away. Oh my gosh, it's terrifying to think my oldest son is 6 years from being 18. But that's the general concepts of, what you want to do when you're thinking about putting a medical power of attorney together. Are you going to restrict anything? So your client may tell you, hey, I don't want this. I usually do not get involved in restrictions. The reason why is, once again, if you overwhelm your client with questions, this just becomes a beating for them, and they don't want to do this. You need to kind of be able to be smart enough to identify when something's an issue. Read the body language. Understand when someone might feel uncomfortable with a decision being made, and skip over the questions that you know how to answer for people. Volume of questions signifies to me, when I walk into a doctor's office or anybody and I'm getting asked question after question, it just signifies to me he doesn't really know what he's talking about. He hasn't done this enough to realize what's important, what's not important, and in getting past that hurdle is very important. Now, I create a separate HIPAA form. So you got to remember HIPAA, what that is that's medical authorization. So people can access medical information. Now, people are going to ask you, I fill out those HIPAAs all the time. We'll be able to explain to them, that HIPAA is for that specific incident. This is if you become incapacitated. And now these are just basic questions. Do you want a disclosure? Where do you want the disclosure statement on medical power of attorneys? You want to disclose how powerful of a document it really is. Now, people don't understand. Out of all the documents they sign, the medical power of attorney is the one that they don't think means very much until someone amputates their arms or legs. And I had a client who had both of her legs amputated by the use of a medical power of attorney that I drafted. And after she woke up, and it was a doctor that screwed up a back surgery. And after she woke up, it was a nightmare. I mean, she did not want that to happen. She would have rather passed away. And I did not explain that to her. So I make sure that is generally the main concern, is the amputation of arms or legs. Okay. And this just allows me to put in the date, where you keep the format. And this is a Texas version of a medical power of attorney. Of course, Westlaw will have every state's version. Every state is going to have a little bit difference, but they're about the same. I mean, they pretty much go for it. Now, HIPAA, it's going to be self-explanatory. Once again, I put the exact same people. This is incredibly important, that you want the same people that are having the medical power of attorney to also be able to access the information. You know, if you don't put the same people in there. One thing I highly encourage right here is where it talks about in succession or as a group. I always do it in succession, and this is why. When the decision comes to make to have the power to make the decision for medical needs, you don't want a committee. You want someone who's going to make the decision. All right. And so I tell people, no, you are going to pick one person to make this decision. If they can, of course, okay, put two in there. But I almost push my clients this way of thinking, because I had a doctor in my office explain, and he's an ER doctor, and he was trying to explain the difficulty to me of trying to negotiate with multiple siblings in a life-death situation. And he said, just give one person the power. So this is a preference when it comes to drafting and the signing ceremony. If there's a document that you can get that's not witnessed, try to avoid witnessing on as many documents as possible, because it just makes the signing ceremony crazy. So if you can get away with not putting witnesses on a HIPAA, that's what I do. The only document that needs to be witnessed in the state of Texas out of a basic estate plan is the will. And so that's the only one. Also in Texas, we don't have to have a trust witness, so I don't have it witnessed, because I don't want my witnesses sitting in here waiting for us to go through each document, because they're my staff and they need to be working. They need to be doing other things, not sitting in a room waiting for people to get through signing things. So that's just a general advice on drafting documents. I refer to, whenever on any of my documents, I refer to settler versus grantor. So on a trust, a settler is a creator of a trust. A grantor is a creator of a trust. I like the word settler because it makes you sound like, this is something really old and mysterious. Yeah, it's just one of my things. I don't really think it has very much bearing on any of that, but I just do that. And be consistent on all your documents. If you use the word settlers in your trust or the word grantor, make sure the medical power of attorney says grantor, because then your client gets confused. Well, what's the difference between a settler and a grantor? Oh, well, they're the same thing. A directed to physician. So remember the difference. Directed to physician, that's they can't save your life. You're in a terminal or irreversible condition, and you're going to die, whether you want them to let you pass away or try to keep you alive as long as possible. Do not resuscitate. Your clients will confuse this all the time, and it's important for you to remember this. Do not resuscitate they can save your life, but don't. And explain to your clients the difference between the two. Yeah, as you can see on Westlaw, it's one question. The living will questions, the directive to physician questions. Durable power of attorney, incredibly important document, and this is going to be advice for later on, is you can use this for basic estate planning, but when you get into elder law planning, you have to have your own form. You can't just use the statutory, the general power of attorney, because you have to add and take away certain languages when you're dealing with Medicaid, because Medicaid will cause problems. And you have to take away things like self-dealing powers and stuff like that. But durable power of attorney, well, who are you going to pick first? Well, I'd pick my wife first. That's who I would want. Because Now, I tell people, the way I explain a durable power of attorney is, who do you want to pay your bills if you were incapacitated? Because people get a little scared when they hear durable power of attorney. They think, oh my gosh, someone's going to run off with money. Well, it's possible they can, but they have fiduciary duties, which would cause them to go to jail if they did run off with your money. So I tell people, being a durable power of attorney is a horrible job. You don't get paid for it, and you could only do the benefit of the person that you're trying to help. Now, who are going to pick my alternates? Of course, I'm younger, so I'm in my 30s, so I'm going to think generationally. I'm going to go my dad, and then I will go. I'm going to put my son in here, and that's a little dangerous because I don't know how my kid's going to turn out. I use the general power of attorney, and this is why. So there's two types of power of attorneys that you can look at: a statutory power of attorney or a general power of attorney. If you're going to go a statutory power of attorney, the problem with a statutory power of attorney is banks don't like them. They don't like that you didn't specifically say they have this power. And so they will always push back against the statutory power of attorney. So I love to draft it. And the general, these are statutory, basically both of them are. General power of attorneys, it's not in the statute, but the general power of attorney just lays everything out. It's 9 pages, it's longer than my will, but I think it solves all the problems. Do you want to give someone a gifting power? No, I don't want to give people gifting power. I don't want, in this context, you might. Well, so where would you want to give gifting power? Well, I would want to give the gifting power if someone was very wealthy and they were getting really old and I might have an estate tax issue coming up. Okay, yeah. I would not want to give a gifting power if I'm trying to get someone qualified for Medicaid, because a gift is a fraudulent transfer. So, you want to think through those things. When do you want this to happen? Immediately upon someone's incapacity? Well, upon someone's incapacity, of course, that's when I want it to happen. Do you want to specifically identify a piece of property? So this is incredibly important to understand. Title companies are the fourth area of law. You need to understand what are your state rules about using a power of attorney to sell real estate. And generally the rule is a title company is not going to let you sell a piece of property with a power of attorney if the power of attorney hasn't been drafted within the last 6 months. In addition to that, the title company is going to want to call the person that has the durable power of attorney, or that the principal, and confirm that they actually did sign this document and they understand what's going to go on. I just had a situation. I own a title company, so we had this situation that happened where I drafted this document for somebody, and dad is he's on the borderline of having Alzheimer's. That's why we drafted it. And my title company wanted to call him and said, hey, we want to talk to him to make sure that he did this. I said, well, we signed this 3 months ago. I don't know if he could really identify what's going on now. And so it created a big problem because of what was going on in his life. But ultimately, we were able to get past it and work through it because the durable power of attorney had been drafted in the last 3 months. And we had a third-party notary go out and basically make sure that in her opinion, that he had the capacity to sign the document at the time. And I made sure that myself, I went out and met with him and was making sure that he had the capacity to sign this document, in my opinion, because I'm not going to draft a document where I don't think the person has the capacity. A lot of attorneys will disagree with this. They'll say, hey, well, I'm not a doctor. I don't identify incapacity. I'm just supposed to draft a document according to, and I understand that. I just do it part of my practice because I don't want to end up in a courtroom trying to explain myself. Let's see. Then this has to do with home equity loans in the state of Texas. Of course, they're different and everything. Will you be recording the durable power of attorney? Now, that's a great question. I generally don't record them because I don't want them to be on the county records. Now, if I have somebody that I know that's going to be using this for real estate, of course, I'm going to put it on the county records because it needs to be there. And what I mean by the county records is that it's going to buy and sell it. So that's the basic questions you get. As you can see, it's a lot quicker than doing a will. The last for these 4 documents for a basic estate plan. It's pretty self-explanatory and simple if you use software. That is the key. Get the software. Make it easy on yourself. Don't try to reinvent the wheel.